Okay, we are on video record. The time is 11:35. I am Edmund Duddleton, a court video specialist. This is a matter pending before the Superior Court of the State of California, in and for the County of San Diego, in the case styled Spotlight on Coastal Corruption versus Kinsey, case number 37-2016-00028494. This is beginning the media 1 of the deposition of Martha McClure on October 11th, 2017, taken at Holiday Inn Express in McKinleyville, California. Counsel, would you identify yourselves and state whom you represent for the record?
Corey Briggs, representing plaintiff.
Joel Jacobs, representing the defendants.
The court reporter today is Dana Harris. Madam Court Reporter, would you please swear in the witness?
Please raise your right hand. Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Good morning, Mrs. McClure. Would you please state and spell your name for the record?
My name is Martha L. McClure. M-C-C-L-U-R-E. I thought maybe that tablet was for me to take notes.
I'm going to be giving you some documents. I didn't want to clutter it up. No problem. Ms. McClure, have you ever had your deposition taken before?
No.
Okay. Let me give you some guidelines to help today go as smoothly as possible. So even though we're in a conference room at a hotel and it's an informal setting, you've been sworn in to tell the truth as if you were in court in front of a judge or a jury. Do you understand that?
I do.
And today I'll be asking you questions. You'll be providing answers. Your attorney may object at times. All of the conversations will be typed up by the court reporter when we're done, and you'll have an opportunity to review the transcript and make any changes to your testimony that you deem appropriate. Do you understand that?
I do.
If you make any changes, however, I could comment on those in front of a judge or a jury, and that could affect your credibility. So it's very important that you let me finish the entire question, make sure that you understand it, ask for any clarification if you don't understand, and then answer the question, because if you answer without seeking clarification, everyone will assume that you understood the question. Do you understand that?
I do.
Good.
Excuse me. Ms. McClure, can you unclip that microphone and put it on your top of your shirt? I think it's getting buried in your scarf. Sorry about that. Thank you.
Should we do a little test? Is that better?
Yeah.
Better?
Yes.
Okay. You're doing a great job so far, but I want to encourage you to continue giving verbal responses to my questions. Sometimes in conversation we get into a rhythm and we'll start shrugging our shoulders, nodding our head, making grunts and groans, and those nonverbal communications can't be interpreted by the court reporter. So if at some point today you give me a nonverbal response, I will say, is that a yes or is that a no? I don't mean to be giving you a hard time. I'm trying to make sure that we have a clean record for the court reporter. Do you understand that?
Yes.
Okay. During the deposition, I may ask you questions that require you to give me an estimate of time, duration, date, number, things of that sort. And I am entitled to your best estimate, but I don't want you to guess at any answers. So if I ask you a question and you have absolutely no idea, you should tell me you have no idea. If you have some idea, I'm entitled to what you know, but I don't want you to guess. And the example I give to witnesses between guessing and giving me a best estimate is I will say, how long is the table that we're sitting at? And if I ask you that question, you'd look at it and say, well, based on my life experience, it's in the 10 to 12 foot range. But if I ask you how long my dining room table is, you would say, beats the heck out of me because I've never seen it. Do you understand the difference?
Yes.
Okay. During the deposition, you may need to take a break, get some fresh air, use the restroom, talk to your attorney. That's no problem. I simply ask that you answer the question that's on the table and then tell me that you'd like to take a break, and I'll be happy to honor your request. Do you understand that?
Yes.
Okay. How many questions before we jump in?
No.
Okay. Where do you live?
Crescent City, California,
How long have you lived there?
30 plus years.
What's your address?
1895 South Pebble Beach Drive, Crescent City, California, 95531.
Did you graduate from high school?
Yes,
When?
1970,
Where did you go?
Del Norte High School.
Okay. Did you go to college?
Yes,
Where?
I went to college, Shasta College for a semester, College of the Redwoods in Eureka for the rest of my junior college, and Humboldt State for the remainder of my degree.
What was your degree in?
Communication theory.
Okay. Did you attend any graduate school or professional school after your undergrad?
I have probably about 70 or 80 plus units after my BA
In what field?
based around education, based with early childhood education through the reluctant learner.
Okay. Do you hold any professional licenses or certificates?
Yes, I have a California teaching credential, life credential.
Okay. Any others?
I don't think so.
Okay.
California driver's license.
No, I meant for work or profession. Okay. Are you currently employed?
Retired.
Okay. What are you retired from?
California teaching and from PERS.
Okay. You were a school teacher?
Yes.
Okay. How many years did you teach school?
30.
What grades?
7 through 12, alternative education.
Okay. Up here in Northern California?
Yes.
Okay. When did you retire?
2 years ago. I'm entering my 3rd year right now.
Okay. Have you ever held elected public office?
Yes.
When?
I was a county supervisor elected in '96, and I held that office through December of 2016.
For which county?
Del Norte County, District 2.
Any other elected public offices that you've held?
No.
Have you ever held any appointed public office?
Yes.
Which ones?
A member of the California Coastal Commission.
Okay. When was that? Approximately.
I think it was 2012 through 16.
Okay. As a coastal commissioner, is it true that you always made your decisions based on the information contained in the commission's official record for whatever item of business was before you?
Yes.
Prior to commission meetings, how did you get your copy of the official record for the agenda items that came before you as a coastal commissioner?
Via email.
Did you also obtain the record from the commission's agenda website?
Yes.
Okay. So sometimes you receive the information via email and sometimes from the website?
I may be mistaken that they were sending me emails. I just knew when it was posted and would go to the website for the posting.
Okay.
There was always a notice sent, but I don't recall if it was email or just by notice on the webpage.
In all likelihood, you received an email informing you that the information was now available on the website, correct?
Correct.
And that's the same website where the public accesses the information, correct?
Correct.
Okay. And is that true from January 1st of 2013 through the end of your term as a coastal commissioner? You would get the official record from the website?
Yes.
I'll object that the term official record in this context is vague and ambiguous, but if you can answer the question, go ahead.
Well, I would like to clarify the date that you said.
From January 1 of 2013 through the end of your term on the commission, you were getting your copy of the record from the website, correct?
Yes.
Okay. Do you have an understanding of what the official record for an item of business before the commission consisted of?
Same objection.
I just want to know your understanding of the official record.
If you're able to answer the question, you should.
The official record is what's recorded by the video recordings and the transcripts presented at the mic.
Along with the information that you get from the website,
Those
correct?
are always part of the That's the addendum that comes with the item that's listed on the webpage.
Okay, so before a Coastal Commission meeting, the record consists of the materials that are available on the website for commissioners and the public to see. And once the meeting's over, the record consists of those website materials along with the video of the proceedings, any oral proceedings that occurred at the meeting, and any written materials submitted at the meeting. Is that correct?
Compound.
Answer.
Unless I instruct you not to answer a question, if you understand a question, you should answer it.
To the best of my recollection, that's correct.
Yeah, this isn't a trick question. I just want to make sure we're talking the same thing. For any particular item of business that comes before the commission, before the meeting, the record is what's available to you and the public on the website, correct?
Correct.
And after the meeting, that website material is supplemented by the video archives, any transcripts of the proceeding, and any written materials that were submitted at the meeting, correct?
Correct.
Okay. Have you ever heard the phrase exhaustion of remedies?
No.
Are you aware that in this lawsuit you have asserted a defense against my client based on the doctrine of exhausting administrative remedies?
No.
Okay. Have you read your answer in this lawsuit?
Yes.
When was the last time you read it?
Probably a week ago.
Okay. Have you read any of the briefs that your attorney has submitted to the court in this case?
Yes.
Okay. Do you recall reading about an exhaustion of remedies defense in any of those briefs?
I don't recall.
Okay. As a sitting commissioner, did you have an understanding that a person who sues the commission over a decision is generally required to inform the commissioners about the problems that the person has with the project up for approval before the person can sue over those problems?
I'm going to object that the question calls for the application of law, the facts, and instruct the witness not to answer.
You've asserted a defense, and I'm trying to make sure that you have an understanding of how commission proceedings work. I don't care about your legal conclusions. I'm asking you as a sitting commissioner, did you have a certain understanding? So I'm going to ask the question again. And I just want you to answer as a commissioner, not as a lawyer or somebody rendering a legal conclusion, okay? Do you understand the difference?
I don't understand your question.
I'm going to ask you a question that I want you to answer based on your experience as a commissioner, okay? Do you understand that?
Yes.
Okay. As a commissioner, did you have an understanding that a person who sues the commission over a decision is generally required to tell the commissioners about problems the person has with the project up for approval before the person sues over those problems? Did you have that understanding, yes or no?
And I'm going to object that that calls for the witness to apply law to facts and is therefore an improper question, and instruct the witness not to answer.
Are you going to take your attorney's advice?
Absolutely.
Okay. Let me state for the record that you are now refusing to answer a question that would provide my client with factual information concerning the affirmative defense that you have asserted in the lawsuit. If you don't answer the questions, I will be filing a motion with the judge to order that you answer the questions under penalty of perjury, and we will fly back up here and do it again. The only difference is the next time I'll be asking the judge to have you pay for all the costs of travel, all the costs of the court reporter, all the costs of the videographer, all the costs of the hotel where we're doing the deposition, my time traveling, my time being here, all of that. And the judge could order you to pay those monetary sanctions. Do you understand that?
I feel that is that you are threatening me as a person who has come here under agreement to tell the truth, and that information I don't understand because I am not a lawyer.
Okay, well, I just want to make sure you understand the possible consequences.
And I believe that you're telling me those consequences based on a threat, asking me to answer a question, and if I don't, then I have to pay for your return. And I'm sorry to hear that because I am here to tell the truth. and I don't understand what you are asking me in relationship to interpreting a law.
Okay, and that's fine. And if you don't understand a question, you should certainly tell me you don't understand
I
it.
don't understand the question.
But I do want to make sure that you understand that your refusal to answer a question that pertains to an issue in this case could result in us having to do this again and the judge ordering you to pay all of the expenses incurred for doing it again. I just want to make sure you understand that that is a possible consequence. It's not a threat. I just want to make sure that you're aware of the possible consequences.
I don't understand the law that provides those consequences. I have never read that law, nor have I ever been asked to interpret that law. And so that rule is foreign to me, and I don't know if you're making that up to threaten me or if that is the case law. But in the interim, I will take the advice of my attorney.
Okay. Did you expect people who had a concern? Would you just mark this set of questions? Thank you. As a commissioner, did you expect people who had a concern about a project over an aspect of a project to tell the commission about the concern before they filed a lawsuit over the project?
I have no opinion of that.
Well, did you have an expectation as a commissioner?
Would you repeat that question, please?
Sure. As a commissioner, did you expect people who had a problem with a project that came before you for approval to tell you what concerns they had before they filed a lawsuit?
I expected the public and people that had interest in a project to come before the commission or to contact the commission of their concerns. I never had that anticipation in relationship to a lawsuit.
Okay. If there were a problem with a decision and you were aware of the problem, but the public was not aware of the problem, would you expect members of the public to alert you to the problem?
And I'll object that it's an incomplete hypothetical and calls for speculation, but if you're able to answer the question, you should do so.
Would you repeat it, please?
Would you please read her the question?
If there were a problem with a decision and you were aware of the problem, but the public was not aware of the problem, would you expect members of the public to alert you to the problem?
I don't know what kind of problem you're talking about.
Well, if there were any problem.
I don't know what kind of problem you're talking about.
Well, if you knew something about a project and the public didn't know about it, would you expect the public to comment on that problematic aspect of the project?
Object that it calls for speculation. It's an incomplete hypothetical. It's vague as to time and context.
I'm talking about when you were a commissioner.
I wouldn't know if there was. I wouldn't know if they. I don't know how. I don't know what you're asking me in relationship. If I knew if there were a problem.
Your expectation.
Wait. I would like to finish, please. That if I knew there were a problem, would I assume that the public knew the problem?
Yeah.
I would have to know what kind of problem, because all of my deliberation was made in public. So all of my decisions were made in public, and my concerns were expressed in public.
Did you have an expectation as a commissioner that concerned members of the public should come to the meetings and tell you their concerns before you made a decision?
I appreciated the public coming before a decision was made on a agenda item.
Did you?
And I appreciated them coming to the meetings and their any documentation that they submitted.
Would you expect members of the public, when you were a commissioner, would you expect members of the public who were aware of a problem to bring that problem to your attention?
Yes.
Okay. And if the members of the public were not aware of a problem, you didn't expect them to bring it to your attention, correct?
Calls for speculation, vague as to time and context.
You can answer.
I am unable to read a mind of someone who may have a problem if they haven't brought the problem forward.
And by the same token, you don't expect members of the public to be able to read your mind, correct?
Correct.
Okay. During your tenure as a coastal commissioner, did you have an understanding of what the phrase ex parte communication meant?
Yes.
What is your understanding?
My understanding is that it is a communication between two parties on a position or a subject matter without the attendance of the others, of people that may be in opposition to that.
I'm sorry. I need to go off the record for a moment.
Sure, let's go off.
We're going off the record. The time is 11:55. We are back on record. The time is 11:57.
Ms. McClure, there were some technical difficulties, so let me ask you the last question again to make sure the video picked up your answer. During your tenure as a coastal commissioner, did you have an understanding of what the phrase ex parte communication meant?
Yes, I did.
And what is your understanding of what the phrase
It
means?
is a meeting between two people with a specific project, with either the applicant or the appellant before the commission.
And please make sure that you've given Mr. Briggs a chance to finish his question before you
Okay,
start your
sorry.
answer.
That's okay. And were the ex parte communications, did they always involve a commissioner?
Yes.
Okay. You didn't mention that in your description, so I just want to make sure I understand.
That I would be there, yes.
Okay, so you understand that an ex parte communication is between a commissioner and either an applicant or an appellant or some other interested person who's concerned about the item of business before the commission, correct?
Correct.
And you're having that conversation outside of a public meeting, correct?
Correct.
Okay. During your tenure on the commission, did you also have an understanding of the rules that governed the disclosure of ex parte communications?
Yes.
And during your tenure on the commission, did you have an understanding that the rules prohibited you from participating in any commission decision if you had not first disclosed any ex parte communications that you had participated in with respect to the subject matter of the decision?
Yes.
During your tenure on the commission, did you ever receive any training from Coastal Commission staff other than attorney-client training concerning the ex parte rules that applied to you as a commissioner?
Can you clarify other than counsel?
Yeah, I don't want to know what any attorneys told you one-on-one privately. I'm
Okay,
interested
but
in-
counsel was the presenter of
Yeah.
the ex parte
Yeah.
workshops.
Right, so we'll get to public meetings in a minute. I just meant, apart from any one-on-one meetings you had with an attorney, did Coastal Commission staff ever give you any training on the ex parte rules that applied to you as a commissioner?
No.
Okay. Did you ever receive any training during public meetings on the rules that applied to you as a commissioner?
Yes.
Did you ever read any of the ex parte rules on your own?
Yes.
When did you first read the ex parte rules?
When I was appointed to the commission.
Did you ever go back and review those rules again over the years to see whether they had...
Yes.
Let me finish the question all the way, please. Did you ever go back and review those rules again over the years to see whether the legislature had changed them?
Yes.
And would you review those rules on, say, an annual basis, more frequently or less frequently?
I don't recall.
How many times during your tenure would you say that you reviewed the ex parte rules?
Unknown, I could comfortably estimate between 3 and 7.
Okay. When you were on the dais as a commissioner, you never fell asleep, correct?
Not that I know of.
Okay. And you were always aware of the fact that you were on the dais, right? You never ended up there by mistake. You were consciously on the dais, correct?
Yes.
Okay. And when you were discussing commission business, you were aware that you were discussing commission business, correct?
Yes.
And when you were voting on commission business, you were aware that you were voting on commission business, correct?
Yes.
What was your understanding of the ex parte rules during your tenure that regulated the timing of disclosures? In other words, what did you understand the timing requirements to be for disclosures?
That ex partes that were prior to 7 days before the hearing were due in excess of 7 days before the hearing, were due in writing, and that the ex parte, had it been within 7 days, could be given at the mic.
So if you had an ex parte communication more than 7 days before the hearing concerning the subject matter of the ex parte, you would have to disclose that communication in writing within 7 days of the communication?
Correct.
And if the ex parte communication occurred 7 or fewer days before the commission concerning the subject matter of that communication occurred, you would then make an oral disclosure on the record at the meeting?
Correct.
Okay. What was your understanding of the substance of the ex parte disclosures? What needed to be disclosed?
What was discussed at the meeting, and the date of the meeting, the location of the meeting, and the time of the meeting, and the people present at the meeting.
Okay. Was it your understanding that your disclosure needed to make a complete and comprehensive disclosure of what was discussed at the meeting?
I believe that I was to report what happened at the meeting in organized fashion, in a statement of the facts that had been discussed at that meeting.
Did you understand that the disclosure had to be a full disclosure of what happened at the meeting?
I don't have a definition of full disclosure.
Well, did you have an understanding that you were allowed to disclose less than everything that was discussed at the meeting?
No.
So your understanding was that you had to disclose everything that was discussed at the meeting, correct?
Correct.
Okay. Did you have an understanding that you were also required to disclose any written materials that you reviewed or discussed at the meeting?
Yes.
And it was your understanding that you were required to disclose those written materials, correct?
Correct.
It was your understanding that you were required to attach them to your disclosure forms, correct?
Not always.
Okay. Under what circumstances would you not have to attach them?
If the staff had already received the briefing document, that briefing document didn't need to be replicated.
Okay, but if staff had not already received the briefing document, you then had to include the briefing document with your disclosure, correct?
Correct.
Okay. During your tenure on the Coastal Commission, what was your practice for submitting ex parte disclosures?
Following the rules.
How would you go about submitting the disclosures?
I would either email it, hand carry it, or at the mic.
So you didn't submit them by FedEx, for example?
No.
You didn't submit them by putting them in the mail, for example?
I don't recall if I ever did.
Okay. And you didn't fax them, correct?
Correct.
So your disclosures made it to the Coastal Commission either via email, or you personally delivering them, or you made them orally from the dais, correct?
Correct.
Okay. Did you have a practice, strike that, when you submitted written disclosures, did you have a practice of getting written receipts or some other documentation showing when you submitted the disclosures to the
No.
commission? Let me finish the question. When you were a commissioner, did you have a practice of getting a written receipt or some other documentation showing when you submitted the disclosure to the commission?
At the very end of my tenure on the commission, that became policy that staff would return an email that they had received the information.
Okay. When did that policy change go into effect?
I don't recall the dates.
This lawsuit was filed in August of 2016. Does that help you recall whether the change was after the lawsuit was filed?
Yes, it was changed after the lawsuit was filed.
Okay, so before this lawsuit was filed, you did not get any written receipt or other documentation showing when you submitted your ex parte disclosure to the commission, correct?
Correct.
Okay. Did it ever occur to you that you should ask for some sort of confirmation of receipt from the commission?
No.
Was it your understanding that if the commission received your disclosures would then be put into the official record for the project to which the disclosures pertain?
Yes.
So the way that the public would know whether you had an ex parte more than 7 days before a commission meeting would be to look at the agenda materials on the website and click on the official record to find your disclosure, correct?
I'm not sure where you need to click, but I know that there's a way of being able to receive that information, usually part of the addendum.
Right. When I say click, I mean the link that includes the agenda materials. Right, the official record that is on the agenda page for the commission is where people would find your disclosures, correct?
And I object to the term official record in that context as being vague and ambiguous.
Well, we've already discussed official record. You understand what I'm talking about,
No,
right?
in fact, I would like a definition of what you're interpreting as official record
Well-
so I can respond accordingly.
Well, I think earlier you agreed that the official record included the materials that were available on the website for a particular agenda item, as well as the video archives and any transcripts of oral proceedings and any written materials submitted at the meeting, correct?
Correct.
Okay. So if we're before the meeting, the official record consists of the materials available on the website for the agenda item, correct?
Correct.
And was it your understanding that your disclosures, if received by the commission, would be included in those agenda materials for a particular item?
Yes.
Okay. Since January 1 of 2013, how many different email accounts have you had?
I need to ask my attorney a question on this.
Sure, let's go off the record.
We're going off record, the time is 12:09. We're back on record, the time is 12:12.
Would you please read the last question to the witness?
Since January 1 of 2013, how many different email accounts have you had?
The answer?
4.
4. What accounts are they?
One account with Del Norte County Unified School District, my personal account, and 2 accounts with the County of Del Norte.
Okay, can you tell me what the email addresses are?
I can tell you all except for the school district because I don't remember if it was, it may have been McClure at dn.k12.ca.us.
Did you ever use the school district email account for Coastal Commission business?
No.
Okay. What were the other 3 email accounts?
My private email account, Martha McClure, all lowercase, at charter.net.
What else?
M. McClure at co.del-nort.ca. I think it was GOV. Or must have been dot. I would have to look it up. It's my email address that I'm certain you have on file.
Okay, and then the third?
M. McClure CCC at co.del-nort.ca.us. That's it.
So you really had two county email accounts, the main difference being the CCC and the address?
Correct.
And did that CCC refer to California Coastal Commission?
Yes, it did.
Okay. Did you use your charter.net personal account for any Coastal Commission business?
No.
Did you ever have an email account through the Coastal Commission?
Yes.
Did you use it?
I think I did, but it was at the very end of my tenure, and it was very confusing of what we were doing, but I did forward all of my email account from the county, both emails, to the Coastal Commission account.
When did you do that forwarding?
When I was given the email account.
Okay, so before the end of your term last year on the Coastal Commission, you forwarded all of your commission-related emails to your Coastal Commission email account?
To the best of my ability, everything went forward to the Coastal Commission account.
Okay. And since January 1 of 2013, have you deleted any emails concerning Coastal Commission business?
To the best of my recollection, I haven't. Well, maybe before the lawsuit, once they were dealt with, I probably removed them. But in my county accounts, it's my understanding that any deleted mail from the county account stays in a delete envelope and can be recovered.
Okay. Did you use your county accounts to transmit your ex parte disclosures, or was that done through your personal charter.net account?
Through the county.
Okay. You didn't use your personal charter.net account for...
To the best
Please wait for the question.
You didn't use your charter.net email account to transmit ex parte disclosures, correct?
To the best of my knowledge, that is correct.
Okay. So if you were only using your county accounts to transmit your disclosures, and those emails, even if you deleted them, remained on the county server, the county would have all of your ex parte related emails going back to January 1 of 2013, correct?
Correct.
Okay. I'm going to show you an exhibit. We're going to mark letter A. Exhibit A is a notice of deposition for today's deposition. I will tell you that there is one change that was made to it. The depo was originally scheduled for yesterday, but your attorney and I agreed to move it to today to accommodate your travel schedule. Do you recognize that notice, other than the date being wrong?
Well, I see the date is wrong, as is the time.
I understand. Apart from that, do you recognize this notice? Have you seen it?
I will have to take a look at it.
Go ahead.
So this says that you're taking the deposition of Eric Howell.
Yes, that is a typo. Looks like yeah, it's for your depo, but the one that you have, your name's in the caption. Right, the body uses Eric's name instead of yours.
So I have not seen one with Eric's name in the body.
Okay, you have seen. Take a look at pages 2 through the end. Do you recall seeing those pages before?
Yes, I believe this is it without going through without spending the time to go through a 12-page, 15-page document, yes.
Yeah, I realize there's a typo on the front page, but...
It makes me uneasy because it tells me I probably should read the whole thing
Well,
before I tell you.
You can go ahead and read the whole thing, because I'm going to ask you questions about it. I want to know whether you've seen pages 2 through the end before today.
May I look at my paperwork?
Of course.
It appears to be the same information that I have received.
Okay,
yes.
great. When you received that information, did you look for the documents described on pages 2 through the end?
To the best of my ability, I did.
Okay. Where did you look for the documents?
I went to anything that I had in my computer. I'm locked out of the county emails, so I could not access those.
Okay.
And I looked through that, and then I went online and listened to all of the depositions that were part of the first case that I was given, of the 42 that I had been given prior to this meeting. But the 42 that I had prior to this meeting did not take into 13. So I have gone over all of these and identified where it's available on the mic.
Okay, we'll go over that in a little bit. Let me make sure I understood where you looked. You looked through your own email records through your charter.net account?
To see if I could find anything.
Okay. You couldn't look through your county emails because you're locked out, correct?
Correct.
And you've been locked out of there since when?
December of 2016.
Okay. Prior to being locked out, had you looked through those email accounts for any documents that might pertain to this lawsuit?
Yes.
Okay. Did you find any documents at that time?
Yes.
What did you do with those documents?
They're still on, to the best of my knowledge, they're still at that email address.
Okay. And do you recall what you found?
I found some ex partes and requests for ex parte meetings, and then a follow-up from the person who was requesting the ex parte would follow up with a description, and then I would read the description and then agree or disagree that that's what we said.
Okay. So whatever ex parte related emails took place through one of your 2 county accounts will be in the county records that they turn over, correct?
Yes. Well, that's my understanding of how it works when things go to storage.
Yeah, okay. As far as you know, the county has all of your ex parte related emails done on one of your 2 county accounts, correct?
Yes.
Okay. And then I think you also said...
I would like to add that they were also, all of those accounts were forwarded to the coastal address.
Right, those, you mentioned that a few moments ago, correct?
Yes.
Okay. So I think you mentioned that you also looked at the video archives and you were comparing them. I think you said to a deposition, but maybe I misheard you. What you said that there were 13 that were somehow not accounted for. What were you saying a few moments ago? You were holding up this piece of paper with some pink markings on it and saying that you looked at the website.
This was the first list that I had received from, I assumed it was from you, but it was the defendant, Martha McClure.
Okay. May I see what you're looking at? Okay, you're looking at attachment 3, which appears to have been from one of the complaints that was filed in this lawsuit.
And I took that and went over every one of those ex partes and recorded went through the record on the video and found my ex partes when they were disclosed, and I have that number on each ex parte.
Okay, and where did you write that number for each ex parte?
Well, I wanted to finish and have it all typed up for you, but I wrote it on my notes in relationship to where I found it. It's all public record.
Okay.
That you would be able to aptly find.
Okay. And these are notes that you've written up for yourself and not notes for your attorney, correct?
Correct. They were in anticipation of wondering what you were going to ask me today.
Okay. May I see those notes?
You'll give them back to me so I can use them, right?
Yes, ma'am. Do you mind if at a break we make a copy of those notes?
Yeah, I think that will be fine. Please be advised that I butcher the last names when I try to write them down or spell them.
That's okay. Okay, so when you looked for materials did I hear you correctly? Not only did you look recently for materials, but you also looked last year after the lawsuit was filed?
We were advised by counsel to save everything, and that may be been the extent of what I looked at that point.
Okay. I'll take Exhibit A back from you. I'm going to show you an exhibit marked B.
Okay, just a second.
Go ahead and take a look at Exhibit B and let me know whether you recognize Exhibit B. Exhibit B is objections to the notice to Martha McClure to produce documents, electronically stored information, and things at a deposition. You seen that document before today?
Yes.
When is the first time you saw it?
I don't recall.
Okay. I'll take it from you.
Okay, and this one was objection.
I'm going to show you an exhibit we've marked as C. Exhibit C is a deposition subpoena that my office issued to the California Coastal Commission on November 3 of 2016. Have you ever seen Exhibit C before today?
Yes, I have.
Do you recall when you first saw it?
No, I don't.
Did you read Exhibit C when you first saw it?
Yes, I did.
Okay. Do you know whether the Coastal Commission turned over any documents to my office in response to this subpoena?
I believe that they gave ex partes, but I would not know the information included.
Did you ever see the materials, if any, that they sent to my office in response to this subpoena?
I do not remember if it was wrapped that way.
Okay. Did you ever compare any of the records in your possession at any time to any documents that you believe the Coastal Commission gave to my office in response to the subpoena?
Yes, I compared the ex partes that were listed on the paper I showed you previously.
But did you compare any of your records to the documents that the Coastal Commission gave my office in response to the subpoena?
I only had the one sheet, so I have no idea what you received other than a list.
Okay, so you haven't made any comparison between your records and whatever records the Coastal Commission may have given my office, correct?
Correct.
Okay. I'm going to show you an exhibit marked with the letter D. For the record, Exhibit D is California Coastal Commission's objections to deposition subpoena, dated November 14, 2016. Have you ever seen that document before, Ms. McClure?
Yes.
When did you first see it?
I don't recall the time.
Okay.
Do you want this back?
Yes, please. While you were a commissioner, do you recall a lawsuit against the commission called Friends of the Canyon versus California Coastal Commission?
Yes.
Okay. I don't want to know about the substance of any closed session discussions, but
That's good.
is it correct that you participated in discussions about this lawsuit in closed session on multiple occasions?
Yes.
Okay. Did you ever learn at some point that the Coastal Commission lost that lawsuit?
Yes.
Did you ever read a copy of the ruling in that lawsuit?
Yes.
Okay. Do you know whether Coastal Commission appealed that lawsuit?
They did not.
Okay. Did you ever vote to appeal the lawsuit?
Yes.
You voted to appeal it?
Well, I don't know if that's a public vote,
Oh.
because it may have been during closed session, but I was in favor of appeal.
Okay. But the commission didn't appeal it, correct?
Correct.
Okay. Was there an aspect of the decision that you believed to be incorrect?
Yes.
Hold on. I think we are wandering into attorney-client discussions here. So you shouldn't talk about what happened at closed session.
Okay.
I'm not asking that. I didn't ask.
I slipped.
I didn't say anything about closed session in that last question.
Okay. And
But my answer, I'm afraid, might have said what was happening in closed session.
Okay, well, let's just focus on the question. Is there a reason that you believe the appeal should have been filed?
And to the extent that your beliefs are influenced by discussions you had with attorneys, you shouldn't testify about them.
No. Let's be clear about something. I don't want to know what your attorneys told you. I don't want to know what you told your attorneys. Not only do I not care, I'm not entitled to it even if I did care, but I don't care. But I'm entitled to know what you think. So, did you think that there was some aspect of the Friends of the Canyon ruling that was wrong? I'm not asking you why you think it. I'm not asking you how you came to the conclusion. I just want to know whether you think there's an aspect of the decision that was wrong.
And I think that given the fact that you're coming at this after having discussed the case with your attorneys, and I don't see how your opinions could be independent of the discussions you had with your attorneys. So I'm going to instruct you not to answer the question. And I know you have questions about particular statements in the decision. We can take those one at a time. If there are factual issues you want to ask about that were in the opinion, those may be perfectly fine. But the overall analysis of the decision, I don't think is appropriate.
Well, that's not what I asked, and I'm going to repeat the warning that I gave earlier because I want to make sure you understand the consequences of not answering.
If you want to put on record that you would contemplate a motion to compel, we understand that you would contemplate a motion to compel and you would seek sanctions. We understand that. You don't need to repeat it every time.
Okay.
We're on notice.
And the witness doesn't need me to repeat that, correct?
Correct.
Okay. When you read the decision, were you in closed session or were you somewhere else?
I read it after it was published on my own.
Okay. And when you read it on your own, did you form an opinion about whether the decision was right or wrong in your mind?
And I think before you answer that, I need to know whether the time period he's asking you about is before or after you talk to attorneys about it. Because if it was...
It would have been after.
Well,
Okay.
let's clarify this. I'll take that question back. Did you read the ruling before or after the closed session meeting at which the lawyers told you that you lost the case?
After.
Okay. And after reading the ruling, which you read after closed session, correct? Yes?
I believe so. It could have been concurrent with closed session because I think it was only about a 3-page document that I saw.
Okay. Let's do this. I'm going to show you an exhibit marked with letter E. Exhibit E is the final ruling from the Orange County Superior Court in the Friends of the Canyon lawsuit from September of 2016. Do you recognize that document, Ms. McClure?
I believe I do, yes.
Okay. Is that the document that you read all by yourself?
Yes, but there was a, I think the staff may have had just a short version, and that's what I read. But
Okay.
I believe I have read this to the best of my recollection. I
Okay,
have.
so just so we're clear, there may have been a staff synopsis of Exhibit E that you also read, correct?
Correct.
But nonetheless, on your own, you have independently read Exhibit E sometime around the time of the ruling, correct?
To the best of my recollection, yes, I did. read
Okay,
it.
and you, when you were sitting by yourself reading this ruling, did anything in it stand out to you as wrong?
And I would caution you that if you can answer that question independent of any discussions you had with attorneys, that's okay. But if your answer would in some way intertwine your own thoughts and the discussions you had with attorneys, you should not answer the question.
I'm sorry, that's not the standard. If it were, we wouldn't be doing a deposition in a lawsuit in the first place, because the witnesses talk to their lawyers about lots of things. You know that's the standard, and so do I. So let's not be coaching the witness on how to avoid answering a question. She's already testified that she read it sitting all by herself. I asked her a question about what she concluded, all on her lonesome. I didn't ask her about the basis. I didn't ask her about communications leading up to it. I just want to know what she thought. Her thoughts are not subject to the attorney-client privilege.
If her thoughts are the result of discussions she's just had with attorneys, then I think that intrudes upon the privilege. And again, just for your guidance, I am much more concerned about questions of yours that get into any sort of legal analysis about the rightness or wrongness of the decision versus if you want to ask her about factual statements in the decision, whether that's consistent with her understanding or her perception, that's fine. And I think you're entitled to that information about what actually happened. But her analysis of the opinion, you're not entitled to if that's the product, at least in part, of her discussions with attorneys.
That's what I'm trying to ask her, and you keep asserting these bogus objections. So let me ask you the question again. Was there some portion of the Friends of the Canyon decision you read that you disagree with on any factual matter?
Can we step out, please?
Yes, if you need to talk to me about a matter of privilege, then we should talk about it.
Sure.
We're going off record. The time is 12:37. We're back on record. The time is 12:40.
Would the court reporter please really read my last question to the witness?
Was there some portion of the Friends of the Canyon's decision that you read that you disagreed with on any factual matter?
Yes.
What portions of the decision did you disagree with?
It can be found on page 9 of the document that you just presented me.
Okay. What part?
First paragraph that describes that There is no ex parte for Commissioner McClure in the administrative record. I disagree.
Was your ex parte for the project that was the subject of the Friends of the Canyon lawsuit in the administrative record?
It was turned in on November 11th, a month before the hearing, and I had had an 8 a.m. meeting on the 2014.
Do you have a copy of the ex parte disclosure that was turned in?
I have a copy of. I read the LA Times, and it said that there were ex partes missing, and it was like, what? So I went to the document, and that's when I read the document. So I now have a time frame of when I reread the document, or when I know I read the document. I may have read it before. And I emailed the person who I had had the ex parte with and told her that I just saw the LA Times article, and I searched for the ex parte for Laguna Canyon Road, and that the file, and I asked that I found my response to her request to ask for an ex parte. But I didn't have the ex parte because that would have been given to me in Monterey, I think it was, or it would have been given to me then, and that's what I turned in when I came into the meeting that morning on the 10th, or what, I'm not exactly sure of the day, but that's when I came into that meeting on the 11th of November, or the 11th of December 2014. When I came into that meeting, I had previously been meeting with the applicant and had my ex parte, and came in with my ex parte, put it down on Vanessa's desk, said, here's my ex parte, and went to the dais where the meeting was then pulled to order.
That was the meeting in December of 2014 when you submitted your ex parte disclosure in person?
Yes. And then I have subsequently, with the help of the applicant, she sent me the copy of what she had given me, because I hadn't received this electronically.
Do you have an understanding of who is responsible for making sure that you comply with the ex parte rules?
I was directed to always give them to Vanessa.
Do you have an understanding of who is responsible for making sure that Martha McClure complied with the ex parte rules? It's a yes or no question.
Yes.
Who did you understand was responsible for making sure that you followed the rules?
I believe I was responsible for delivering the information to the staff, and staff was responsible to put it in the record.
Okay, what makes you think that staff was responsible for putting it in the record?
Because that's how it worked.
Do you have any reason, do you think that you were responsible for making sure it was put into the record?
No.
So you think that once you gave staff your copy of the disclosure form, you had done everything the law required of you?
I had done what I was required of, and then subsequently I reported it at the mic that I had turned it in, and the date and the location of the ex parte.
And you didn't...
But it was a month later.
And you didn't think to ever confirm that staff had put your disclosures into the record?
No, I didn't.
Why not?
Because that happened on a regular basis throughout my tenure, not to me personally, but to other commissioners would report that it should be on record, but it's not in the addendum.
Well, did you ever say anything to Coastal Commission staff when you observed that you had turned in a ex parte disclosure form, but it wasn't in the online materials?
I don't believe I would have ever said anything directly to staff, because I believe that the hierarchy is that I should talk to the director, and there were conversations that I had with the director, saying I have a problem with stuff not hitting the record on time.
With which director did you have that conversation?
Charles.
Charles Lester. When?
Throughout his tenure as director.
On how many occasions did you have a conversation with Charles Lester about your concern that your disclosure forms were not making it to a project's official record?
Unknown how many, at least once, but possibly as many as 5 times.
When was the first such conversation?
I don't recall.
When was the second such conversation?
It's my belief that those discussions would have come around about through evaluation. So I think I should not talk anymore about it.
Did you ever put in writing your concerns that your disclosure forms were not making it to the official record?
I had no understanding that my disclosure forms were not making it until I found out in 2016.
When in 2016?
When I read the LA Times on June 6th, on June 9th, July 9th.
So before July 9 of 2016, you had no idea that your ex parte disclosure forms were not routinely put into the official record for a project, correct?
Correct.
But you had access to the materials on the Commission's website for projects before the meeting, right?
Correct.
And you opened those files and read all the materials there, correct?
Correct.
And you never noticed that your ex parte disclosures were missing?
When I reported it out that it was not in, that I should be on the file.
Well, should be on the file or is in the file?
I reported it as should. I wasn't alarmed that there was an issue. I made the assumption that it was a lag in paper that they had because the staff is very stressed with the amount of work they have, and sometimes those things get listed later.
So you knew when you looked at the agenda materials that your disclosure form wasn't there, even though you had turned it in weeks beforehand?
1 month beforehand, yes.
And how many times were you aware that you had turned it in a month beforehand but weren't seeing it on the agenda, on the online agenda?
I believe that was my only missing submitted email. It's my disclosure.
So you think this only happened one time?
For me.
For you. So, with the exception of the Friends of the Canyon case, where you believe that staff just dropped the ball, in all of the other instances when you turned in your disclosure forms, if you turned it in, they made it to the official record that was available on the website?
I would not have that knowledge.
Well, you testified earlier that you went to the website and you would download the materials for each agenda item and review them, correct?
Correct.
And did you ever notice that your ex parte disclosure forms were missing, even if you would have turned in the disclosure form earlier?
No.
Okay. Did you look through the agenda materials ever to verify that any ex parte disclosures that you submitted were in fact posted in the materials?
Only this case.
So you never, with the exception of the Friends of the Canyon case, you never looked at the online agenda materials to confirm that the staff had received your ex parte disclosures, correct?
To confirm that the staff had recorded my ex parte disclosure?
Yeah, you never did that verification, correct?
I did not.
Is there a reason?
Yes, because the agendas come out 10 days before the meeting, and many times they're 17 to 1,800 pages. And the addendums are always at the back. And to me, the important part of what I needed to cover was the application and the staff recommendation, and then the appellant's their issues. That's what I was focused on. And for me, I truly didn't go through and look. There's usually 3 or 4 pages at the end of ex parte notes. But no, I did not look because I had no reason to believe that it wouldn't make it to the final record.
Did you know when you were a commissioner that you were prohibited from participating in any decision until your ex parte communication was fully disclosed?
I had fully disclosed them.
Were you aware that you could not participate in a commission decision until all of your ex parte communications on that item had been fully disclosed?
Yes.
Okay. So you knew that you couldn't participate without full disclosure.
On this one, when I saw it, yes.
Well, didn't you know that on all of your
I don't-
Please wait for him to finish the question.
you knew that on all of your decisions you couldn't participate in them until all ex parte disclosures for that particular item had been put into the official record, correct?
Calls for a legal conclusion, but go
Did
ahead.
you know that?
I thought that I had finished my job when I turned it into staff.
Listen carefully to the question. I'm not asking you what you thought about finishing your job. I'm asking whether you knew that you could not participate in any commission decision if your ex parte disclosures had not been put into the official record for that decision before you voted. Did you know that?
Yes.
Okay. And even though you knew that, and even though you were reading the agenda materials that are available to you and the public online, you never attempted to verify that the commission had received your disclosures, even though they didn't appear in the agenda materials, other than the Friends of the Canyon case. Right?
Misstates the testimony.
I'm sorry, what?
I just made an objection that it misstates the testimony, but if you're able to answer, you should.
Yeah, I don't know what you're saying.
I'm trying to understand how it's possible that someone like you, who knew you couldn't participate in a decision unless all your disclosures were put into the record first, someone who is looking at the record online in preparing for the meeting, someone who presumably knows if she had an ex parte communication, and presumably knows if she submitted her disclosure form, would not say something publicly if she saw that her disclosure forms were not making it into the official record.
But hold on. It's argumentative and not in the form of a question. But if you're able to answer it, go ahead.
Right, what's the question?
Yeah. Am I accurately describing you?
No.
Okay. You did know that you couldn't participate in the decision until your disclosures were made, correct?
Correct.
And you knew if you had an ex parte communication, correct?
Correct.
And you knew if you submitted a disclosure of the communication, correct?
Correct.
And you knew when you submitted the disclosure, correct?
Correct.
And you read the agenda materials for the items that came before you as a commissioner, correct?
Misstates the testimony.
Did you read the agenda materials for the...
Yes.
Let me finish. Did you read the agenda materials for the items that came before you as a commissioner?
Yes.
And you got those agenda materials from the commission's website, where every member of the public gets them, correct?
Correct.
Okay. When you read those materials, other than the Friends of the Canyon case, were you ever concerned to see that ex parte disclosures that you had submitted more than 7 days earlier were not on the website?
Asked and answered.
You can answer.
Go ahead.
Say it again. I'm sorry.
Can you ask my last question? Read her my last question, please.
When you read those materials, other than the Friends of the Canyon case, were you ever concerned to see that ex parte disclosures that you had submitted more than 7 days earlier were not on the website?
No.
Why were you not concerned?
I don't believe that there were any other ex partes that were submitted that didn't make it to the record in a timely manner.
Okay. Do you have an understanding of the reasons why ex parte communications are to be disclosed?
Yes.
What's your understanding?
My understanding is that I need to share information that was given to me by either the appellant or the applicant in relationship to the application, and that needs to be shared in a public way.
Do you understand that the reason for the disclosure is so that people who don't get to participate in these private meetings have the same information that was exchanged during the meetings?
Yes.
Okay. So you didn't think...
May I add something?
Yeah, sure.
Sure, if you have more to say
That
in
even
response to the question.
on this report where it wasn't there, I did say on the mic that my ex parte should be on file, but here's when I met. And then I reported it out because I hadn't seen it. I didn't even know I hadn't. That's how I just prefaced everything. But I always reported them out on the mic.
Was there anything else in the Friends of the Canyon decision that you factually disagreed with?
Can you be more specific?
No?
Then I would have to say that I can't answer that question because it doesn't have enough information in it for me.
I asked you the question earlier and you directed me to the top paragraph on page 9.
Mm-hmm.
You also testified that you read the entire decision, correct?
Mm-hmm.
Yes?
Yes.
Okay, so if you read the entire decision and you could point me to the top paragraph on page 9, can you point me to any other portions in the decision that you believe are factually incorrect?
I believe the other information that I believe is incorrect is attorney-client privileged.
Okay. Is there anything factually discussed in the Friends of the Canyon decision that you believe to be incorrect other than what's in the first paragraph at the top of page 9?
I'm not sure how to answer that because I didn't agree with not putting in the appeals.
Well, hold on. Okay, that's legal. He's asking you factually. Are there any factual statements in the opinion that you remember disagreeing with when you read them? I think that's the question.
I believe I don't know how to, because this was where the disagreement was. So I believe that is the accurate record of what the court presented.
What is the accurate record of what the court...
This Exhibit C.
Okay, so, sorry.
Exhibit
You
E.
believe that Exhibit E is otherwise accurate except for the statement at the top of page 9 that you...
I believe it's an accurate document that the court produced, yes.
With the exception of the paragraph at the top of page 9,
Correct.
right?
Well,
And please don't talk over him.
sorry.
I just want to make sure we're on the same page. Other than the top paragraph on page 9, you believe that the Friends of the Canyon decision is otherwise factually correct. Do I have that right?
Yes.
Okay. I'm going to show you an exhibit marked with the letter F. Exhibit F is a letter that I wrote to the defendants in this case and Kamala Harris on September 26 of 2016. Ma'am, do you recognize Exhibit F?
Yes.
Do you recall when you first saw it?
No. I would assume it was shortly after the 26th of September.
Okay. And you haven't destroyed any evidence in this case, have you?
To the best of my knowledge, I have destroyed nothing.
Okay.
I would suggest maybe after this exhibit we take a break. We've been going a while.
Sure. Let's take one now.
Okay.
Let's go off the record.
We're going off record. The time is 1:01.
I will